Hello, and welcome to the Legal Concierge podcast hosted by Warner Lewis. Warner addresses a wide range of questions about legal situations and solutions that may apply to you. The information provided in this podcast is for educational purposes only and is not a substitute for legal, financial, or medical advice of any kind. Warner Lewis is a trusted, reliable resource to help you find the answers you need when you're not sure who to turn to if you have a legal question or need an attorney. Chat with Warner live, every Tuesday on YouTube. And now, here's Warner Lewis.
Hi all, greetings to the Legal Concierge. I'm Warner Lewis. If you tuned in on Tuesday, the original date of this broadcast, and every Tuesday, we had some significant technical difficulties and we made the executive decision on the fly to just go ahead and quit and come back today. We got all of our technical legal issues sorted out. I'm really grateful to our producer, Toby and Shelley, and to my son, Lev, and to Rick, who came in and saved the day. Took the younger generation about an hour to come and set everything up so it's perfect. So technology is wonderful when it works, and now it works great. So happy to have you here. Thank you so much for joining us today. Today we have a very special segment on asset protection planning. Many of us wonder what would happen if we were to get into a car accident or get sued by way of a civil matter or a business matter. How can we protect our assets? What are the options that are available to us so that we can perhaps rearrange our affairs in a way that would allow us to not lose everything right off the bat? I think that's the key concept. So I'm going to ask you, just to remind you to like, share, and subscribe this podcast. It really helps us to grow the channel and to spread the word. All of these podcasts are being archived up on YouTube so that one can go anytime and search our page and find topics that are of interest. And that's really our goal, is to provide legal information on common legal areas, common legal topics that could lead to actionable information. So if you feel like you need to or want to get your estate planning in order, to get your business planning, your LLCs in order, and to set up an asset protection structure or any of these, a combination of any of these, then we can help. And the Legal Concierge, beyond those areas of law that we help clients with, estate planning, business planning, and asset protection planning, any other kind of matter, whether it's divorce, bankruptcy, tenant, landlord, any of the hundreds of different areas of legal needs that most of us have from time to time, Legal Concierge can help at no cost to you to understand your circumstance and find a practitioner, a legal practitioner, a lawyer, an attorney who is best suited to resolve that, help you resolve that issue for you. It costs you nothing. And it's a high-level, white glove concierge service that I think you or people that you care about might find to be very, very beneficial if the need for legal assistance arises. So today we're going to talk about asset protection planning. And so we're going to talk first about these key concepts. What are the key concepts around asset protection planning? So first, the cornerstones of estate planning. Proper estate planning includes the wills, trusts, and powers of attorney, which allow us to avoid probate and to ensure that people that we trust, know, and like are making financial and medical decisions for us if we're incapacitated and cannot make them for ourselves. So these are really important documents that, pretty much everyone who has assets and people that they care about, like children, want to have in place, because for peace of mind, first of all, and because we care about the people that we love and we don't want to leave them in a lurch in case something happens to us. Life is a terminal condition. I'm sorry, I hate to be the buzzkill, the guy to remind you that nobody gets out alive. So it's one of those things. It's really inevitable. And planning for our eventual potential incapacity and certain passing, this makes an awful lot of sense to do this kind of planning. The second part or key component of asset protection planning is the business planning side of it, that forming the LLCs or the corporations in certain combinations, which we'll talk about in a moment. So it's so important when you create an LLC, for example, and I'll just use the term LLC throughout, We'll talk about some differences between LLCs and corporations in just a moment, but generally speaking, LLC, limited liability company, we're going to refer to as an entity that is designed to help limit our personal liability in the event of a lawsuit or something like that. So it's so important when we're forming an LLC to do it correctly. You know, what's the structure? Is it going to be member managed or manager managed? You know, who the different individuals would be who play the various roles, like statutory agent and that sort of thing. But then once you have the LLC properly created and properly formed and documented, it's so important to continue to update and maintain the paperwork requirements, meeting minutes and that sort of thing, in order to achieve and maintain compliance. 90 plus, maybe 95% of existing LLCs will fail to protect their owners in the event of a lawsuit or an audit because they are not properly documented or administered. So that's something to keep in mind. And then at the higher level of asset protection planning, we can accomplish not only asset protection or some form, some level of asset protection, but also privacy. It is possible to have the ownership of your entity to be private from prying eyes. That's not to say that information would not be disclosed under a court order or a judgment from a court, but right off the bat, it is actually pretty easy to create privacy around one's business affairs. So keep that in mind. So some key concepts. So we start with the beginning. You know, at the foundation is a holistic overview and approach to your unique circumstances, and then to design strategies that reflect your unique circumstances. Remember too that titling of assets, in other words, how you own property, determines their treatment upon your incapacity or your death. And different titling, the different ways to title your assets, generate different outcomes. And some of those outcomes, as we'll find out today, are not that desirable. So when we talk about protecting assets, asset protection, we're really talking about building up walls tall enough and strong enough to discourage someone who's driving by our $1 million house free and clear to, in a lawsuit or some similar circumstance, to try to take that away from us. So we try to build these tall walls, which we'll talk about techniques on how to do that. The supreme irony about protecting your assets, about asset protection, is that in order to protect your assets, generally speaking, you have to give them away. So we'll be looking at some of those strategies that have been around for decades and decades that in effect allow us to give assets away in a controlled manner so that we can enjoy protection for those assets. So that's an interesting irony. In order to protect your assets, you have to give them away. I want to caution, though, that the one universal truth about asset protection planning is that you can only plan when the coast is clear. In other words, if you know that if you're involved in a lawsuit, or you expect that you may be involved in a lawsuit, or even the reasonable anticipation that a lawsuit could arise down the road, you cannot do that kind of asset protection plan. In other words, changing ownership of your assets, because the law, the lawyer for the opposing counsel would say that's a fraudulent transfer. The law says it's a fraudulent transfer. You're trying to change ownership of your assets in order to beat a creditor out of what they might reasonably be entitled to receive. So you can only do it when the coast is clear. You can't do it when the waters are muddy. And then finally, just keep in mind that there's no guarantee that any asset protection planning that we do is going to be on a best efforts basis only. And I believe that any practitioner who's involved in asset protection planning would agree that they cannot guarantee that your assets will be completely protected from creditors, judgments, lawsuits, unless, for example, you give them away and you wait for 5 years to pass. Now that is a completed transfer into an irrevocable trust, which means you can never enjoy 1 penny's worth of benefit from those assets that you're giving away. And it's even subject to a long look back period, where if a lawsuit came up within 2, 3, 5 years from the transfer, they would claw those assets back into your name so that they could be taken from you. So asset protection planning, welcome to the topic. It's an interesting one. So basically, here's some strategies that we're going to be talking about. 1 is avoiding joint tenancy. 2 is the concept of severing community property, or severing joint tenancy property in order to help protect those assets. And some of those techniques include reciprocal marital QTIP trusts, which we'll talk about in a moment, qualified personal residence trusts, QPRTs. So those are interesting techniques that we'll talk about. And then the single member LLC, which provides great internal liability protection, versus a multiply owned LLC, a multi-member LLC, which can, if structured properly, also provide us with good external liability protection. And I'll explain the difference between internal and external liability in just a moment. So if any of these initial topics have piqued your interest and you'd like to contact us for an initial consultation that's at no cost and no obligation, feel free to call the local number in Scottsdale, Arizona, toll-free number from anywhere in the country. Or you can schedule a 15-minute, 30-minute, 60-minute, or 90-minute Zoom meeting, phone call, or in-office visit by going to my Calendly link. That's where my calendar is at www.calendly.com/Warner-1. So that's how you get a hold of me, okay? Oh, the first question is, does an LLC protect personal assets? Thank you, Matt at MinSocial. I appreciate that very much. You know, typically a limited liability company, an LLC, is generally intended for business purposes, like a rental property or an operating company, something like that. Typically, if one puts one's personal residence into an LLC or a bank account into an LLC, there's no business purpose to that. So chances are that probably would not be a good strategy. So there has to be a business purpose to it, okay? So is there such a thing as guaranteed asset protection? No, absolutely not. There is no guarantee. I don't believe there's a practitioner in this country who would say, without a doubt, unequivocally, yes, if you do this, then they can't get a hold of your assets. Unless, like I mentioned before, you give them away to an irrevocable trust and you'll wait 5 years, okay? So that's a pretty onerous, most of us aren't at the point where we're willing or able to give up our assets, just give them away and never see them or enjoy them or benefit from them ever again. So call us if any of these topics are of interest to you. We'd be happy to talk through with you your circumstance, talk about options perhaps. And if we can help you, great, that's up to you. If your legal need goes beyond our area of competence, then we can certainly refer you to an attorney who is very competent, supremely competent in that area of the law. And that's what the Legal Concierge does, is make sure that you're in the best possible hands when dealing with your legal issues. Okay. So now we're going to talk a little bit about joint tenancy versus community property. Joint tenancy, first of all, if we take a look at joint tenancy, many people, so the survivor is going to be the sole owner upon death. So if you and I are joint tenants with rights of survivorship and I die, you inherited 100% lock, stock, and barrel. But here's one way that joint tenancy can, a couple of ways that joint tenancy can backfire. So first of all, joint tenancy avoids probate at the first death. Now there's the first death that transfers by operation of law 100% to the surviving joint tenant. But some of the issues, it does not solve the problem of avoiding probate at the second death, though, because joint tenancy with rights of survivorship gets it to the survivor at the first death, but then at the second death, the death of the survivor, that property gets stuck in their name and therefore probate is typically required. So if you are joint tenancy or have been joint tenants with rights of survivorship, the other owner passed away and now it's just in your name, you probably have some planning needs that should be addressed so that you can avoid dying, owning that property in your own name and kicking off a probate process, which from personal experience, I can tell you is not a pleasant one. So interesting thing about joint tenancy is that joint tenants are joint and severally liable for the other. So we often see like a widow or a parent who names their child as a joint tenant with them on a bank account or on a house, just so that if something happens, okay? But let's say that mom, who puts her daughter, who's local, on as joint tenant on the bank accounts in the house. Mom passes away, that one daughter inherits it lock, stock, and barrel, but doesn't consider the other siblings who live on the West Coast and the East Coast. By virtue of joint tenancy with rights of survivorship, that one daughter owns it lock, stock, and barrel. Doesn't matter what the will says, doesn't matter what the trust says. She owns it 100%. Now she's going to have to figure out in her heart if all of the money she'd have to give up by doing the right thing and splitting it 2/3 to the other siblings and 1/3 for herself, that can be a tough choice for a lot of people when there's money on the table. So I don't want to focus on sort of the dark side of people's personality sometimes where the greed takes over, but this happens quite a bit. And I'm sure that many of you who will hear this today or hear it at some point in the future can relate, either in your own family or close relatives' family or friends' family, where some renegade person took advantage of everybody else. And so good planning will help to avoid those kinds of problems. So if joint tenants are joint and severally liable, let's say that the mom and the daughter gets into a car accident and they sue the daughter. And now they do a search of all the daughter's assets and they find the daughter on mom's house as a joint tenant and on mom's bank accounts as joint tenant. And because joint tenants are joint and severally liable for the actions of the other, now mom's bank account and house are subject to the lawsuit against the daughter. So these are some of the many unintended consequences through joint tenancy that one needs to consider when setting up joint tenancy, okay? Because joint tenancy only goes so far and then can lead to a series of circumstances that are out of control. And one solution rather than joint tenancy, I had a case in this week, unmarried couple who own a house together. They want to keep their home interests separate, so they create separate trusts for their interest in that one house. And it's possible to do that. You can have 50% of a house in your trust and 50% of a house in the other owner's trust. And that way you control your half of the house. You could give it to the survivor at the first death, to the surviving owner of the house, or you could give it to your children or whomever you please. And so you actually have a lot of control over how your property passes, when it passes, and to whom it passes just by doing some great planning. So here is talking a little bit about community property. Now, community property is somewhat different from joint tenancy property. The first one that comes to mind, it's the same thing where the survivor is the sole owner upon death. That's the same. It avoids probate at the first death, but it does not solve the problem at the second death. And just like joint tenants who are not married, spouses who have community property with rights to survivorship, they are joint and severally liable for the actions of the other as well. So we're going to look in a moment at how we can adjust ownership between husband and wife so that if one gets into trouble, they don't get the whole pie. They just get the injuring party spouse. They get their half. So a couple of those solutions involve severing joint tenancy or severing community property. And a married couple, will do that through a contemporaneous property agreement, saying it was community property and now we wave a magic wand over it and it's our separate property 50-50. It's possible to do that. And that way, if one spouse gets sued, they only get half of the whole estate, right? So that could come in handy if, let's say, one of the spouses was an anesthesiologist. Really not a question of if they were going to lose someone on the operating table and perhaps get sued, but when and how often. So this is one of the forms, the lowest hanging fruit, if you will, of asset protection planning is severing joint tenancy, making each one the separate owner, and severing community property, making each one a separate owner. So if any of these topics regarding joint tenancy or community property, we didn't even get into the taxation differences, and there are some. So if you have any interest in these topics, then go ahead and give us a call or go to my calendar and let's schedule some time to discuss your personal circumstances, okay? The tax consequences of joint tenancy with rights to survivorship. This is a great question. With joint tenancy, let's say a property is owned in joint tenancy and the first spouse passes away or the first owner passes away. Let's say they bought the house for $100,000. And at the time of the first joint tenant's death, the house was valued at $200,000. So the step up in cost basis occurs at 2 times with joint tenancy. The first time as to the value of that property at the first death, and the second time as to the value of the property at the second death. So if you purchased the home for $100,000, it was valued at $200,000 at the first death. The first owner to die has a $100,000 capital gain between $100,000 and $200,000, and they owe half of that tax. Then at the second death, let's say the house was worth $400,000. Now you have a new cost basis at the second death, so you have a bifurcated cost basis. At the first death, $200,000. At the second death, $400,000. You combine those and divide them in two. I know it's complicated, but $600,000 divided by two, $300,000 is the combined step up in cost basis under joint tenancy with rights of survivorship. That means that if the ultimate owner, who inherited by will or trust, were to receive it and sells it for $400,000, their cost basis is $300,000. Therefore, they'd owe capital gains tax on $100,000. Now, there is a lifetime exemption that each one of us has that we can use to offset capital gains on the sale of real estate. It's a total of $250,000 that we can basically skip or avoid paying capital gains tax on. But that's a lifetime exemption. And with community property, the difference is that you get a full step up in basis and cost basis as to the value of the property at the second death. So if you bought the house for $100,000 and at the second death it was valued at $400,000 and it was owned as community property, and the new owner, the children, for example, who inherited, sold it for $400,000, there would be zero capital gains tax owed. So that's a big difference between joint tenancy and community property. And of course, if one is married, most married couples own their jointly owned property as community property. One of the big reasons is the benefit of step up in cost basis. A quick note on step up in cost basis and capital gains tax. Under the new tax plan that's been talked about, the $7 trillion one, they had talked seriously about doing away with the step up in cost basis altogether. So if you purchase the property for $100,000 and your children receive it when you die and it's worth $400,000, the capital gains on the difference in value between 103 and 400, that's $300,000 in capital gain. That tax would be owed upon the second death, upon your children inheriting it, and apparently even without selling the property. So they'd have a significant tax bill that would be due whether you sold the property or not. So these are, it sounds like, I spoke with someone last week who told me that based on their research, that neither the House nor the Senate are likely to pass that provision, doing away with the step up in cost basis, which is great news. We'll see what happens in the end, but we'll just see what happens. It's hard to predict exactly what's going to happen. So if you have any questions about joint tenancy, community property, and how it's taxed, go ahead and touch bases with us, call the office, or go right to my calendar and schedule some time, and we'll talk about it, okay? So let's see. Let's talk about QTIPs and QPRTs. Those are qualified terminal interest property trusts. So remember we talked a moment ago about the most foundational form of asset protection planning that a husband and wife can do is to sever community property and each take title to one half of their, take one half ownership interest in the entire estate. So that if one gets sued, they get that, spouse's half, but they don't get the whole thing. Now, here is a strategy that has been used over the past many decades, and it involves severing community property so that each spouse owns 50% of the estate, creating qualified terminal interest property trust. That's QTIP, QTIP, Qualified Terminal Interest Property Trust, where each spouse transfers their 50% into their QTIP trust. They are the trustee of their half of the QTIP trust, of the estate going into their respective QTIP trust. But the other spouse is the beneficiary. So now that the spouse has just given away right, title, and interest of their sole and separate 50% to their spouse. And they've done it reciprocally. They've done it for each other. And the question comes up, well, what happens if you divorce? Well, everything's split 50-50 already. So the property split in the divorce would already be accomplished. So the other spouse is the beneficiary of my QTIP. And typically speaking, if it meets certain criterion and certain time frames, it's outside of the reach of creditors, judgments, lawsuits, and divorces. But the exception, again, is that you can only do this kind of planning while you can, or when you can, when the coast is clear. There's no actual lawsuit underway or no anticipation of a lawsuit or an action arising. So it's really important to keep in mind that you can only do this kind of planning when it's, when the coast is clear. Let me see here. Okay, QPRT. This is a bit of a different strategy. The QPRT, a Qualified Personal Residence Trust. This is where we take the home. Let's say you have a home, your primary residence or your vacation property, because you can put a primary residence and a vacation property that's more than, I believe, 50 miles away from the residence. You can put two properties into the QPRT. And a QPRT is a Qualified Personal Residence Trust. Whenever you see the word qualified, like a qualified plan, an IRA, 401k, qualified personal residence trust, qualified means that generally speaking, it's outside of the reach of creditors. So a qualified personal residence trust is where the spouses transfer their respective 50% ownership into their QPRT, which the other spouse manages, okay? And the deal is that the QPRT provides for the gifting of the house to the children, typically, in exchange for the right of the parents to live in that house for their life expectancy. So let's say the parents are in their 50s and there's a 27 or 38 year life expectancy. That's how long the parents can live in the house rent-free until the children can say, hey, mom, dad, it's time for you to start paying rent. Now, most children won't say, hey, mom, dad, it's time to start paying rent. But it's really interesting because the QPRT allows you to give the house away and yet still retain the right to live in the house for a period of basically based on your life expectancy. Spouses live there rent-free. Children are beneficiary. The children are beneficiaries of the QPRT. And because of the word qualified, it's typically outside of the reach of creditors. So if you have any questions about QTIP trusts or QPRTs, Qualified Personal Residence Trust, go ahead and touch bases with the office. Happy to talk with you about different strategies for protecting your home and your financial assets, okay, using reciprocal QTIP trusts. Terrific. All right, let's go on to our next topic. We're going to look at revocable living trusts compared to irrevocable living trusts. And the big difference is that, well, revocable trusts are the cornerstone of any sound estate plan. Irrevocable trusts are the fortress, the castle that we wrap around assets that protect those assets for the beneficiary's lifetimes. So a revocable living trust avoids probate to the extent that assets are funded into the trust, as opposed to a will, which requires probating if it's in the trust, which prearranges who's going to manage it and who's going to receive it, how and when. There's no court involvement. Everything that's in the revocable living trust, properly drafted, avoids probate. Revocable trusts become irrevocable upon death by their nature. So they go from being revocable, revocable trusts do not protect your assets. Irrevocable trusts do a great job of protecting your assets. The trick is that with many revocable living trusts disgorge the money by distributing it outright and free of trust into the names of the beneficiaries. That means if a beneficiary who inherits in their own name drives home from mom or dad's funeral and they injure someone in a car accident and get sued, because that inheritance or life insurance policy or IRA distribution is in their name, it can be taken from them by creditors, judgments, and lawsuits. But if we retain those assets in further trust, then we provide a protective wrapper around these assets that your children will inherit from you. So that's a big, big difference. And with irrevocable trusts, you protect those assets by giving up ownership, but not giving up control. One can still be a trustee of an irrevocable trust. We also are going to look at IDGITs. I know this is a complicated sounding entity, and an IDGIT is an intentionally defective grantor trust. I'll show you where those get used in more complex asset protection planning structures in just a moment. But it's ideal to have multiple owners of an entity, like a holding company, that owns everything else, operating companies, rental properties. We're going to take a look at that in just a moment. So if you have any questions about revocable or irrevocable trust, go ahead and give us a call, schedule some time, and we'll talk about your circumstances, okay? So what are the advantages of irrevocable trust versus revocable? So a revocable trust means that you can change it. You can amend it, you can revoke it, blow it up, take everything out of the trust back into your own name. But an irrevocable trust, once you have created the trust and funded it with whatever you're going to put into it, technically speaking, you can never get that back. You can never enjoy a penny's benefit from it. And it's a completed transfer. You've just given it away. That's one way to protect it. Especially if you're giving it away to your children, like the QPRT, to your children, in a sense, or a life insurance trust, an irrevocable life insurance trust. That money that you give away to the irrevocable life insurance trust, you can enjoy, but your children, if they're beneficiaries of the ILIT or the irrevocable life insurance trust, that could pay for their education, for example. So you have to consider the control that you give up by creating irrevocable trust. But most people set up the revocable trust, enjoy their money during their lifetime, and then upon their death, their trust becomes irrevocable, and irrevocable trusts do a great job of protecting assets that your children will inherit from you. So again, if you have any questions about revocable and irrevocable trust, contact us, and we'll be happy to walk you through your options and understand what your questions are and provide you with some good answers. So now we're going to talk about LLCs. LLCs are considered building blocks or the foundation of asset protection planning. And I'm going to explain the difference between a single member LLC and a multiply owned or a multi-member LLC. There are some big differences. But first, when we're talking about this kind of planning, business planning, creating LLCs or corporations, we need to understand your existing structures first and make sure that they're structured properly, like manager managed, for example, as opposed to member managed. There could be an advantage in that structure, manager managed versus member managed. We can talk about that if you touch bases with us. There are some pros and cons associated with LLCs compared to corporations. And one of those is that the shares of a corporation are actual physical stock certificates. Okay, it's like 100 shares. That's a thing, as opposed to an ownership interest in an LLC. A percentage interest in an entity it's a theoretical thing. It's a quotient. It's a mathematical idea. It's not a thing. So in theory, in the event of a judgment, one might prefer to have an LLC because those ownership interests expressed in a percentage ownership of a company are harder to take away from you. But if you have shares in a corporation, shares can be taken from you. So that's one thing to consider when we're setting up asset protection structures. Is an LLC going to be better under certain circumstances, or is the corporation going to be the better solution? But with either a corporation or an LLC, that maintaining compliance with the rules around administering your trust, document your LLC or your corporation, whether it's having bylaws and having organizational meeting minutes, ongoing meeting minutes, annual meeting minutes, banking resolutions, company stock certificates or ownership certificates, a company seal, and operating that LLC or corporation as if it was truly distinct and different from you. Where people sometimes get into trouble is that they create an LLC in name only. They've established the LLC with the Corporation Commission or the Secretary of State's office, but they haven't done anything to meet the administrative requirements and the rules regarding properly administering the LLC or the corporation. So in the event of a lawsuit or an audit, typically the first thing that they do is ask to see your company record books, the operating agreement, organizational meeting minutes, all of that. And most business owners cannot present a pristine set of company records. So this is part of our opportunity and of our challenge, is helping business owners achieve and maintain compliance with those rules, so that if they are audited, if they are sued, then they have the corporate documentation in place. So no matter what you own, it's so important that what you own, whether they're shares or ownership interest in an LLC or in a house or a bank account, it's so important to make sure that your asset is properly titled, because how you title an asset, if it's in your name and you die with it in your name, it's going to probate. If you die and it's in a revocable trust, it becomes irrevocable upon your death, and it could be protected for future generations. Big difference. So the key to success, of course, is structure and compliance. So let's talk about the limited liability company. A single member LLC provides great internal liability protection. So if I own a rental property and that rental property is owned by an LLC that's owned and controlled by my trust, because the LLC is owned by my trust, it has one owner. Single member LLCs provide great internal liability protection. In other words, if someone slips and falls on my rental property, breaks a bone, and sues the owner of the rental property, I prefer that they sue my LLC, properly documented so that it will withstand the pressure of a lawsuit better than if there was no documentation. I would prefer that they sue the LLC where my liability is limited to what's in the LLC. So they can take that house, that rental property, but they can't jump over the wall in theory and get to everything else that I own. Now, again, the danger of not documenting and administering an entity properly in the event of a lawsuit or an audit by the IRS, they look and say, okay, you don't have company record books. You're operating your entity, your LLC, as your alter ego, as if it was you. It's not a separate entity. It's the same as if it's you. Therefore, we're disallowing your deductions or we're making you personally liable. Okay, that's the big difference. You have to maintain it properly. So the law says that every action that you take on behalf of the LLC must be by written consent. In other words, you have to give yourself a permission to obtain an EIN, to file articles of organization, to name yourself as manager, to open up a bank account. All of these things need to be written down, giving yourself permission according to the law. If there is no written consent, in theory, it can make you personally liable. Oops, that's not what you intend when you create an LLC, right? So it's really important to mind the rules that govern the administration and documentation of your entity. The corporate veil, which most of us think we get, that corporate veil of protection between the entity, the rental property, the operating company, and my personal assets, that corporate veil is actually pretty easy to pierce if one can demonstrate that, oh, the LLC was just a pseudonym or as if it was me, not a distinct entity separate from me. We estimate that 95% of existing LLCs will not protect their owners in the event of a lawsuit or an audit. So this is a widespread problem. If your LLC is properly documented so that it can provide great internal liability protection, someone slips and falls on your rental property, sues the owner of the property, that's the LLC, and they get what's in the LLC. They can't jump over the LLC to get to everything else that you own. That's great. Provides great internal liability protection, but provides zero external liability protection. So what happens in that circumstance? This is that no asset protection structure that most people have. You have the Revocable Living Trust, which owns your home, brokerage accounts, bank accounts, your personal property, and it owns your operating company, LLC, or rental properties, or whatever other business type interests you may have that are in LLCs or corporations. The trust owns everything. So you don't own and control you don't own the operating company, your trust does, but you as trustee and you as an individual are the same person. So you control the entity that owns the property. That's great. But by that very same token, because you can put stuff in, take it out, put it in, take it out, blow up the trust, take everything back into your own name if you wanted to. By that token, a revocable living trust does not protect your assets, but it will avoid probate, okay? So if you were to have a car accident, for example, and injure or kill other people, and they sued you personally, remember you as an individual and you as trustee are one and the same person under the law, they sue you personally, they can get through the revocable living trust and get to everything that you own. So that provides great internal liability protection, but not external liability protection. So multiply owned LLCs, however, in contrast to a single member LLC, where there's more than one member, First of all, they're subject to the new LLC law. So this uniform LLC law that was created by the American Bar Association and given to all 50 states, and the 50 states are one by one adapting and adopting the uniform LLC law to their own state-specific parameters. So in the state of Arizona, we've adopted the Arizona LLC law, which all multiply owned LLCs in the state of Arizona are subject to the requirements of this new LLC law, which says, first of all, that all multiply owned LLCs this year, 2021, and moving forward, must have a new LLC law, an ALCA, Arizona Limited Liability Company Act, ALCA, compliant operating agreement. So the drawbacks are many, though, in the way this law is set up. It's possible to draft around some of the more onerous requirements of the new LLC law. The new LLC law says that members, for example, just a couple of examples, a member can sue another member for really a frivolous anything, frivolous or not. Oh, you didn't disclose that every Tuesday afternoon you have to go pick up your child from school. And that makes you less effective, and therefore you haven't disclosed that, and you aren't living up to your promises and your duties, so we're going to sue you as a member of the LLC. We can draft around that ability saying, no, we're not giving members the ability to sue internally for those kinds of issues. Another big onerous requirement of the new LLC law, the Arizona Limited Liability Company Act, is that upon winding up a multiply owned LLC, let's say you own 60% of an LLC and I own 40%, and we're wrapping up and we're distributing and closing down the LLC, those proceeds, those distributions are 50-50, not 60-40 or 90-10. It would be required under the law that they be split evenly, pro rata, equally among all of the owners. So this is a huge problem. If you were 90% owner and I was 10, upon winding up, you wouldn't want me to get half of the proceeds, would you? So the only way you can avoid that kind of onerous outcome is to have a specially drafted ALCA compliant LLC operating agreement. So multiply owned LLCs also have asset protection benefits. It's harder to get a charging order or a judgment against an LLC that has two owners, because you wouldn't just be harming or getting a judgment against one of the two owners, for example, you'd be injuring them both. They would both be involved, and that's not cricket. That's not okay under the law. So it makes it harder to get a charging order or a judgment against a multiply owned LLC. So if you have higher net worth, this is usually a structure for individuals with $3, $4, $5 million in net worth and up. In high-risk professions, for example, doctors and others who are often sued. A multiply owned LLC, as you can see in blue here, is a firewall, in a sense, between external liability, a car accident, and being sued as a result of having injured people in a car accident. The multi-member holding company is multiply owned. It's owned sometimes 90% by your Revocable living trust and 10% owned by an IDGIT or an irrevocable trust of some kind. It could also be your children or other people whom you trust to be that other 10% owner. So it's multiply owned. Spouses, by the way, cannot take this approach between themselves because husband and wife are considered one and the same person under the law. So it has to be someone other than the individual or the married couple to be that second owner. But a multi-member holding company can own all of these sub-LLCs, like your operating companies, your LLCs, those kinds of things. And if one were to be sued, there's no guarantee of asset protection, but it would certainly slow down your creditors and make it more difficult for them to just take everything that you own. So that's the idea on a best efforts basis of what this multiply owned holding company structure can do. Another benefit too is that if we set up these multiply owned holding companies in states like Wyoming, to some degree, New Mexico and Delaware, there's still an opportunity for privacy where you don't have to disclose who the owners of the holding company are. Now, the statutory agent would be required, not the statutory agent, but the Corporation Commission would be required to disclose who the owners are of that multiply owned holding company in Wyoming, for example, under court order or subpoena. But otherwise, it's very difficult to get to that information. So privacy is actually still possible, and asset protection is still possible under certain circumstances by using more complex structures like these multiply owned holding companies. If you have any questions about single member LLCs versus multi-member LLCs, bringing your multi-member LLC in Arizona up to compliance with the new ALCA rules, the Arizona Limited Liability Company Act, the new LLC Act rules, go ahead and call us. We're doing a lot of those. And remember, every Arizona LLC that is multiply owned requires to have an operating agreement that's compliant with the ALCA law, the new LLC law, according to the law itself. So what do I recommend for asset protection with property management? That's a more complex question. Many of our clients who have multiple LLCs, multiple rental properties, will have each of their rentals in their own LLC. So that because if you put two properties into one LLC, just like two apples in one barrel, and one of them goes bad, they both go bad. But 2 properties, 5 properties, 10 properties in one LLC, and somebody slips and falls on one of the properties and sues the owner of the LLC, they sue the LLC that has 9 other properties in it. So in theory, your risk is limited to everything that's in the LLC. So many times we rearrange the allocation of assets among LLCs to manage that risk better. Maybe 1, 2, 3 highly encumbered properties into one LLC. Because they're encumbered, you owe 90% on each property. There's not that much equity. So you can pile a lot of those rental properties into one LLC. But if you have a free and clear house that's worth $1 million, $2 million, and you're renting it, you don't want to put 2 of those into one LLC. Another question from Launch Real Estate. Thank you for your kind questions and your attention to this podcast. This is our 3rd show, essentially. And so we're getting up to speed, and I'm hoping and glad if you do find some value to the information that we're providing to you. So Launch Real Estate asks, what are the basics that need to be done for compliance with an LLC? Do you have a guide or a download for this? No download per se, but what needs to be done, the general guidelines are to have a properly drafted operating agreement, to give yourself permission to do all the things that you've done in the form of an organizational meeting, the minutes of the organizational meeting. That very first meeting that you hold, that you conduct with a brand new LLC, gives you permission to file the articles of organization, to name yourselves as managers, to open a bank account, to get an EIN, to select a cash or accrual method, gives you permission to contribute personal property or cash, assume debts and obligations. I mean, that's the 6 or 7, 8 page original document that breathes life into your LLC. Then you might conduct a meeting minute right after that one that says it gives the members and the managers the authority to go and get an EIN number and open up a bank account. Between those documents, you're off and running, you're in good shape. Now, the other side of that is having meeting minutes, because remember, you have to give yourself written permission for everything that you do on behalf of the LLC. So the ideal is 15 minutes per year. That's 12 monthly meeting minutes, a semi-annual meeting, that's twice, that's 14, and then one final meeting, the annual meeting, that's 15 meeting minutes. Now that's overkill for a lot of, especially small businesses or singly owned LLCs, right? So what we do is use sort of an all-encompassing meeting minute that we do annually that says on this date, we created an accurate record of a meeting that took place back in 2008. So when we go to document, we take a lot of existing LLCs that have been around for sometimes decades, and we go back and forensically recreate the operating agreement and all those other documents. Plus, we create past annual meeting minutes that say, on this date in 2021, we created an accurate record of a meeting that took place back in 2008, giving the members and the managers permission to have done everything they did in 2008 and everything that they will do in 2009. So we kind of leapfrog years, covering generically, giving permission generically for all of the actions that we took that year and that we would take the following year without being specific. Then typically if someone is audited or sued, that's when we might go back in and look at the check register and see quarter by quarter, or even month by month if necessary, to see the actions that the LLC owners took in purchasing a property, replacing an air conditioner, doing new carpeting, hiring a contractor. These are the kinds of things that we would drill down on in more detail in the event of a lawsuit or an audit. But generically speaking, we rely initially on the annual meeting minute. And then if more details of meeting minutes are required because of a lawsuit, then we can go back and forensically recreate those. Hope that answers the question. Thank you so much for your question. So some final thoughts around all of this. Give me just a moment. So these are the essentials of asset protection. First, keep in mind, there's no guarantee. All of these structures and attempts that we make at structuring ownership of assets in a way that will build a wall around your assets are really based on best efforts only. That's no guarantee that they're going to actually keep a creditor or a judgment from getting anything that you own. But it does tend to slow down the process, gives you a little bit more equal footing in terms of negotiations, for example, that sort of thing. You can only do this kind of planning when the coast is clear and there's no expectation of legal action on the horizon. The irony is that in order to keep your assets, you have to give them away. Spouses, keep in mind, can do more than unmarried people can do with those marital QTIP, the reciprocal QTIP trusts, where they split their estate 50-50 and then they name the other spouse as the beneficiary of their QTIP. So essentially they've given their assets away to their spouse. It's important that we design and implement each portion, each phase of this protection process, that we implement them and design them by the book. It's, if you go the cheap route and, you find an operating agreement, a 7-page operating agreement that was used by somebody, back in the early 2000s, that's cutting corners that can actually come back and it costs you much more than the money that you save from having done it right the first place. So if that makes sense, you might want to spend the money and get it done right rather than have to ask for forgiveness or deal with a deficient structure down the road. It's important to continue to review your plan periodically to make sure that we modify the plan as circumstances change and as laws change. Remember, the new Arizona Limited Liability Company Act, the new LLC law, requires that you update your operating agreement to be in compliance with the ALCA rules. So if your entity, your LLC, has more than one member, you might want to give us a call and we'll talk about some of your options. And then, of course, one way to avoid a lawsuit is to be conscious and responsible and mind your own safety, right? Conduct your life and your activities like driving in a car. Be safe. Take some time to be conscious and not create trouble for ourselves down the road. It's probably a pretty good idea. All right, what's left? Oh, so the process. If you wanted to engage us in a conversation around all of this, the first thing to do would be to schedule a no cost, no obligation consultation. We'll review all of your existing documents, your wills, trusts, LLCs, corporations, buy-sell agreements, all of that. We'll answer all of your questions, provide you with enough legal information to make fully informed decisions. So we're not lawyers, we're certified legal document preparers. We don't have a legal opinion. We'd never say you should do this, you shouldn't do that. That would be a legal opinion. But we can give you legal information with impunity so that we can say, if you do this, this is the result. If you take this approach, this is what you can expect. But other people want to wind up over here, so here's the approach they take. In other words, giving you enough legal information to make fully informed decisions. That's the approach that we take. Then we're really good, competent at preparing documents that accurately reflect your circumstances, your goals, your needs, your wants. It's very important not to have just a one-size-fits-all cookie-cutter result or approach. Everyone is different, and we pride ourselves in making sure that everyone's documents accurately reflect their wishes. Where most trusts and other plans fail is the failure to properly implement the plan. So with the trust, for example, once you have the trust in place, you can't just say, okay, fine, that's done. You have to change the title of your home, for example, into the trust. So from you as husband and wife, we create a deed that transfers ownership from you as husband and wife to you as trustees of your trust. Now that property is in a trust, and upon your passing, it will automatically be distributed according to the terms of the trust and completely avoid probate. The same is true of your bank accounts, brokerage accounts, life insurance, IRAs, those kinds of things. And we'll talk more about funding trusts here in the next week or two. Very, very important. To have just a trust without funding it or implementing it properly is a waste of time and money. So work with a company that will make sure to get all of those to help to get the real estate into the trust or into LLCs owned by the trust, and then who will kindly remind you, badger you if need be, to go to the bank with your certification of trust. Tell them you've created a trust and have them help you change ownership of your assets into the trust, because if it's stuck in your name when you die, whether you have a trust or not, whether you have a will or not, it's going through probate. And of course, we're all about helping people avoid probate. And then finally, once you get this done, you may want to consider becoming an advocate among your friends and families, colleagues, coworkers, because, about 10% of the population is wired to want to check that off their box. Okay, I've been worrying about what happens if I pass or become incapacitated. I'm getting my will, trust, and powers of attorney done. Boom, done. But most of us, mere mortals, right, tend to procrastinate. We tend to be in denial a little bit. And we just, it's in the back of our minds, but we don't think about it much and we don't take action. So the benefit of getting it done yourself and then being an advocate among your friends and your family members. Hey, I just got my will and trust done. It was a great process, really easy, cost effective. You should go talk to my guy. So whoever that is, whether it's us or someone else, go take that first step, pick up the phone, make an appointment, and begin the conversation. And keep in mind that if you're the one who just got it done, most people will never wake up in the morning and just say, oh, I'm going to open up the yellow pages and find a lawyer whom I don't know, I don't trust, I don't know if I'm going to like them. I'm just going to call them, get an appointment, and I'm going to spill the beans and tell them everything about how I feel about my money, my children, and all of that. That's why most people don't do it. But if a friend of yours or someone that you trust comes to you and says, hey, I got this done, that could be the spark, that could be the catalyst that gets them to actually make the phone call and get their own affairs in order. So don't minimize the power that you could have, the positive effect that you could have over friends and family's lives once you get this accomplished for yourself. So again, as always, any questions about any of this, go ahead and give us a call or go online to my calendar. Calendly.com/Warner-1. Thank you very much for your accolades, Matt. Appreciate you very much too. And we will come back to you next Tuesday, the 23rd. No, that's the day before Thanksgiving, 2 days before Thanksgiving. I think we'll go ahead and do that one too. So we'll look forward to seeing you soon, and hopefully we'll get a chance to talk with you before too long. Toby, thanks so much for rolling it. Appreciate it. Bye.
Thank you for joining the Legal Concierge podcast hosted by Warner Lewis. Please subscribe and leave a comment or question regarding your own legal situation, or ideas for future shows. Share this podcast with your family and friends so they can find answers regarding legal situations and solutions, too. Check the show notes for links and resources, and please come back again next week.